What would you do if a single guilty plea could either erase a felony from your record or send you to prison for years? In this intense courtroom session, Judge Fleischer lays out life-changing consequences in real time, from deferred probation opportunities to shocking bond increases after failed drug tests. Some defendants walk away with a second chance. Others leave facing much higher stakes. Stay until the end, because one decision in this courtroom changes everything.
Ms. Rogers, in cause number 25 DCCR 0976, you're charged with the state jail felony offense of theft of service from June 5th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you actually did what they charged you with?
No.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes and no.
And do you fully understand them?
Yes and no.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes and no.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes and no.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,536. Is that your understanding?
Yes and no.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Rogers is not competent?
No, Your Honor.
Any reason not to go forward in
No,
doing restitution?
I know, Your Honor, her record's clean in this instance.
So I'm going to waive the pre-sentence report, Ms. Rogers. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow that agreement that you made with the district attorney. Defer all proceedings for 2 years, so you'll be on probation for 2 years. You're ordered to pay $2,536 in restitution and to follow all of the other rules and conditions of probation.
Okay.
If you do that, this is a great opportunity because you don't have a felony conviction on your record.
Yes
And if you successfully complete the probation, at the end, the case is actually dismissed and you'll never have that conviction.
Okay.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty and you could go to the state jail prison for between 6 months and up to 2 years.
Okay.
You understand?
Yes and no.
Also, it is very important. 2 years seems like a long time potentially to pay off that money, but it's going to go by pretty quickly.
Okay.
I want you to start making payments immediately. Even if it's a little bit, it'll add up.
Okay.
Because what can happen is if you don't make payments on that, and at the end of your probation period, I find that you could have paid, you could do 2 years of probation and still be revoked for not paying it.
Okay.
So make sure you get that paid, okay?
Yes and no.
All right, if you, I'm handing you the trial presentation that this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. She's at that desk right there, so kind of pay attention for her to call your name. Okay?
Okay.
All right, good luck to you, ma'am.
Thank you, Your Honor.
Thank you. Good morning, you're Allison Strong.
Yes and no.
And Ms. Strong was previously in court, entered a plea of guilty to assault on a peace officer. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
I have, Your Honor. I have, Your Honor.
Are there any additions or corrections?
And the Lord, Judge. Not my statement.
All right, Ms. Strom, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to follow all of the rules and conditions of probation, including you will be on the mental health caseload so you can get whatever type of help necessary so that you can be successful on your probation. It's important that you follow all of the rules and conditions through the mental health caseload, through regular probation. If you do everything you're supposed to on this probation, it's a great opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you're successful, the case is dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you become a convicted felon, and you could go to prison for anywhere in that punishment range, which is between 2 years and up to 20 years in prison. Do you understand?
Yes.
All right. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up when she's ready to go over your paperwork. Good luck, ma'am. Good morning, sir. You're Presley Viltz. And Mr. Viltz, let me get this pulled up. Sorry. Okay. In cause number 24, DCCR 2312, you're charged with a state jail felony offense of unauthorized use of a vehicle from August 1st of 2024. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in the state jail prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. For a 5-year deferred probation, there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. That would be a type of probation where you don't have a felony conviction on your record if you do it successfully. Do you understand?
Yes, ma'am.
You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject this offer and have your case set for trial?
Yes, ma'am.
And is there any reason to believe there would be any different?
In my conversations with Ms. French, I don't believe that there's any reason that his offer may change, Judge.
Okay.
There is a dispute about the facts right in line.
Okay.
If there's a factual dispute, Judge, that me and Ms. French are talking about since she's taking the case over.
Sure. So if anything changes, just let me know. So Mr. Bills, well, let's do this. Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? You will keep Mr. Lewis. Mr. Lewis, then we'll get with Ms. French. If anything changes, just let me know before the trial date. Otherwise, we'll set it for trial. Okay.
Okay.
All right. Stay in touch with Mr. Lewis.
Thank you. I've heard that.
Yes, sir. You too. And so Mr. Foray tested positive for THC, cocaine, methamphetamines, amphetamines, and benzodiazepine. So obviously, there was some information that Ms. Malfino had that I did not as to why we should test, but there's something going on here. And that's clearly a violation of the bond in both of the cases. I'm going to find that you have violated the bond conditions in cause number 26 DCCR 0047. Raise your bond in that case. Let me see what it's set at. Give me just a second. Okay, thank you. So in 0047, I'm going to raise the bond in that case to $50,000. I'll go over conditions in just a second. And then the first one, do you have that one? Clause number 25, DCCR 1458. Raise the bond in that case to $25,000. Condition in each of those, a bond in each of those cases, if you make those bonds, is that you have a drug patch on at all times. You will have to have a drug patch within 24 hours of your release from custody. They get changed every 2 weeks. If it tests positive when you get out, it's a violation, and obviously your bonds will go much higher. Do you understand?
Yeah. So. Okay.
All right. You can go back with the bailiff.
Courtroom moments like these show how fast life can change with just a few words before a judge. If you're fascinated by real courtroom drama, plea deals, and high-stakes decisions that impact lives forever, make sure you subscribe now and turn on notifications. You don't want to miss the next case, because the next ruling could be even more shocking.